From the nation's capital, the American Enterprise Institute for Public Policy Research presents Public Policy Forums, a series of programs featuring the nation's top authorities presenting their differing views on the vital issues which confront us.
Our subject, how to interpret the Constitution. I am Robert Goldwin, Director of Constitutional Studies of the American Enterprise Institute, and I will serve as moderator. And to help us understand this issue and think it through for ourselves, we have with us a distinguished and expert panel of judges and scholars. To my far right is Laurence Tribe, the Ralph Tyler Professor of Constitutional Law at Harvard Law School. Professor Tribe is the author of many books and articles, including Constitutional Choices, God Save This Honorable Court, and the widely used textbook, American Constitutional Law. On my immediate right is Circuit Judge Abner J. Mikva, who serves on the United States Court of Appeals for the District of Columbia. Prior to his service on the bench, Judge Mikva was elected 5 times to the U.S. House of Representatives as a Democratic congressman from Illinois. On my immediate left is Circuit Judge J. Clifford Wallace, who serves on the United States Court of Appeals for the Ninth Circuit. Judge Wallace was previously a United States District Judge for the Southern District of California. Finally, to my far left is Walter Berns, the John M. Olin University Professor at Georgetown University and an adjunct scholar at the American Enterprise Institute. A political scientist, Professor Berns also is the author of many books and articles, including In Defense of Liberal Democracy and soon to be published, Constituting America. Recently, the nation has had an extremely unusual public exchange of views on this issue, on the issue of how to interpret the Constitution, with the Attorney General of the United States on one side of the argument and a sitting justice of the Supreme Court on the other. Speaking before the American Bar Association, Attorney General Edwin Meese argued that the only legitimate way for courts to interpret the Constitution is to be guided by the original intention of those who wrote and ratified the document. Judges who depart from that standard of interpretation, he warned, substitute their own personal whim for the will of the American people. When that happens, he said, the idea of democracy has suffered and the permanence of the Constitution has been weakened. A Constitution that is viewed as only what the judges say it is no longer a Constitution in the true sense. Associate Justice William Brennan, soon after, expressed a sharply different view of this jurisprudence of original intention. In a speech at Georgetown University, he argued that it is arrogant to pretend that from our vantage we can gauge accurately the intent of the framers. Typically, all that can be gleaned is that the framers themselves did not agree and hid their difference in cloaks of generality. Those who would restrict claims of right to the values of 1789 specifically articulated in the Constitution turn a blind eye to social progress and eschew adaptation of overarching principles to changes of social circumstances. These two statements bracket the problem of how to read and apply the Constitution when we need its guidance in making laws, executing the laws, or deciding legal controversies. Mr. Meese and Justice Brennan point out clearly and forcefully the difficulties and the dangers. On one side, if we disregard the intention of the authors, it may lead to disregard for the text, the words and provisions of the Constitution and what they were intended to mean. What then, other than the personal preferences of the judges, will be the law? As Mr. Meese would ask, if the Constitution is only what the judges say it is there a Constitution? On the other hand, Justice Brennan points to difficulties with the attempt to find the original intent of the framers because they disagreed on much in the Constitution while it was being written and subsequently. And even if the original intention can be known, he asks whether we can allow ourselves to be held back by the views of a time long dead and gone. Must we not read the Constitution in a way that permits social progress in accord with the times? According to these two opposing views, if we follow the lead of the Attorney General, we have a sense of constitutional stability, but the danger that an 18th century document is used to prevent 20th century social progress. And if we follow Justice Brennan's lead, social and political change is facilitated, but we run the risk of lawmaking by the courts, constitutional amendment not by the amending process, but by judges. Now, with the problem thus before us, gentlemen, I put the same question to each of you and ask, what is your answer? How should we interpret the Constitution? Judge Mikva.
Well, at the risk of trying to meld the unmeldable, neither Justice Brennan nor Attorney General Meese said what the others said they said. Justice Brennan never said that the Constitution is what the judges say it is, and Attorney General Meese doesn't really want to spell every S like an F and insist specifically that the Constitution can only mean what it says and what was done in 1789. I think the paragraphs that you quoted are the polarizations of this constant dilemma that we've had since the Republic started. Obviously, the Constitution has meanings. It is intended as limitations. It used to be taught in law school when I was there as a course in constitutional limitations. And clearly, it is intended to limit not only what Congress can do, but in turn what the judges can interpose in it. Take, for example, the issue of voting, something I know a little bit about. As late as the 1860s, when the 14th Amendment was adopted, there were a lot of limitations on who could vote in this country. Women couldn't vote, people who didn't own property couldn't vote, slaves couldn't vote, and even when the 14th Amendment was adopted and slaves could vote specifically in the Constitution, there were still these other limitations. But by the time the 1950s came around, we had removed by constitutional amendment and otherwise the limitations on property holdings, the limitations on women voting. I don't think it was unreasonable for the court in Baker versus Carr to say that if sex and race and property are not relevant limitations on the right to vote, then clearly geography should not be a limitation on the right to vote. And I think that today even the more conservative scholars would acknowledge that Baker versus Carr was not a revolutionary break from constitutional law. So I would say that you have to read what both the Attorney General and Justice Brennan say and remember both of them when we're trying to decide these awesome cases.
Judge Wallace, what's your answer? How should we interpret the Constitution?
Well, I suppose the basic question is, how do we provide for social change? The focus is always on the courts for some reason, and perhaps during this next hour we'll be able to ventilate why those reasons are. But the Constitution set up a means of governing a people, and it didn't allow just the courts that responsibility. Indeed, it didn't give it the main responsibility. And we have a tendency to look at the courts, I sometimes think, in a vacuum without recognizing that the framers, in their wisdom, had an overall process for governing the people. The idea, as I understand it, was that the people, through their elected representatives, would provide the voice for social change. I think if you believe in this basic democratic process, it governs how you feel about the courts and what their role is in interpreting the Constitution. And then with certain individual rights that are protected by the Constitution, certain processes. Aside from those areas, that the courts would allow the people's representatives, the elected representatives, to make their decision about social change, even though the courts sitting in its position may think politically or sociologically it's a wrong decision. The courts, in essence, in this role are anti-democratic. They can overrule the majority. And when there are lifetime judges exercising this very important power, it seems to me that they need to be wary of these anti-democratic forays and be careful about allowing the legislature and the executive to carry out their responsible positions under the Constitution. So if there is something to restraint and it means that, I tend to think restraint more as respect for the other branches. And I would align myself, as far as my basic philosophy is concerned, in that area.
Professor Tribe?
It's obviously a very large question to which we're asked to give a quite brief answer. It seems to me that in answer to the broad question, how should we interpret the Constitution, it's important to begin with the fact that it is a living, legal document. It is a legal document designed to endure and to constitute a society, a political society, but it is a legal document. Reading it is radically different from the process of writing one of your own. There are many things I would like to have in the ideal Constitution. Occasionally I've helped other countries write them that I can't find in our Constitution. But on the other hand, trying to read the Constitution in accord with the specific brainwaves and mind states of those at the time they drafted it, who were the authors of the document, would, I think, quite paradoxically, be incompatible with the broad original intent of the framers, which was to launch into history a document that would endure and that would evolve. When they wanted to be very narrow and precise and specific, they knew how. They talked about a requirement that the president be 35, not be sufficiently mature. On the other hand, in other parts of the Constitution, they spoke more capaciously. They talked about cruel and unusual punishments, about the privileges of national citizenship, about due process of law, about equal protection. It seems to me, therefore, that our task is to read and understand the text in light of its context and in light of its structure, of course focusing on the intent of the document as a whole, but not in a process that resembles the psychoanalysis of the private, subjective states of mind of the authors, in a process that rather identifies intent as a general, objective, public fact. From that point of view, it seems to me that we're dealing with a document that, when it speaks in generalities, should be respected for that choice.
Professor Berns?
Well, for reasons having to do with Republican principles, which are stated for our purposes in the Declaration of Independence, it seems to me quite obvious that when it comes to interpreting the Constitution, we are bound by the intent of the framers. Now, the intent of the framers is in that text. One doesn't attempt to psychoanalyze the framers or read their autobiographies. One has to read the text of the Constitution. And it seems to me that that text is a lot clearer than is sometimes suggested by those who say it's filled with generalities and we are of necessity free to roam as we please. For example, in that particular speech at Georgetown that Mr. Justice Brennan, that you quoted from him, the latter part of that speech is given over to a discussion of the death penalty. He's opposed to the death penalty. He's not only opposed to the death penalty, but he's firmly persuaded that it's unconstitutional. Now, he comes to that conclusion not because he cannot read the Constitution. He can read the Constitution at least as well as I can read the Constitution. And when he reads the Constitution, he sees 5 particular references, specific references in the text of the Constitution indicating that capital punishment is absolutely constitutional. There is a reference in the 5th article of amendment, permitting capital trials if they are preceded by a presentment or an indictment of a grand jury. A person's life may be put in jeopardy once, but not twice for the same offense. A person's life may be deprived with due process of law, but not without due process of law. The 14th Amendment repeats that particular provision. And then, of course, in Article 2, Section 2, I think, the President is given the power, the President is empowered to issue reprieves. 5 particular specific references in the text of the Constitution making it absolutely clear that there's nothing unconstitutional about the death penalty. Justice Brennan, nevertheless, having talked about the magnificent generalities of the text of the Constitution, comes to the conclusion that the death penalty is unconstitutional. Question, by what right does he do this?
If I could interject, I'm not, at this point, going to try to defend the conclusion that the death penalty is unconstitutional. I find that problematic, but I find your reading of the text very difficult. That is, what all of those provisions, it seems to me, indicate is that insofar as death is used, it must be used in accord with various safeguards. That presumes that perhaps death will be allowed, perhaps it won't. The cruel and unusual punishment clause makes that an open question. For example, when you referred to not twice being put in jeopardy of life, it actually doesn't just say life, it says life or limb. I suppose that means that we could hack off people's arms.
Yes.
But it doesn't say you can hack people's arms off. It leaves that question for interpretation of the cruel and unusual punishment clause. And I dare say that all members of any court I can imagine would now say that lopping off the arms is a cruel and unusual punishment.
Tribe, if you were on the court and you had a capital punishment case, as they have every year now, would your conclusion be that it's unconstitutional?
I think probably not. I would be delighted by a constitution that barred capital punishment, but I'm inclined to say that it is not yet cruel and unusual. But it seems to me the fact that I differ with Justice Brennan on some points and with Chief Justice Rehnquist on others is not to the point. The question is, and I think I agree with you, we must read the text to discern intent. But how are we to go about reading the text? Are we to read it with all of the negative implications that are conceivable, or are we to read it in a way that is consistent with the idea of a document capable of growth?
Obviously, we would not be here discussing this issue if it were simple.
Right.
And one would have to be a fool to argue that it is simple. But I would like to put the question to the two judges on the panel. To what extent are your difficulties derived from 14th Amendment cases, which provide the bulk of the constitutional litigation now, I would suppose?
What clauses do you have in mind?
Well, I mean, due process, equal protection, those two clauses. I just, see, the original text of the Constitution, I think, is not difficult, not so difficult to interpret. The difficulty comes with the 14th Amendment, which seemingly is stated in these generalities.
Well, there's no question about the large amount of work that we do that involves the 14th Amendment. In flying back to Washington today for this, I was reading briefs for next week's calendar, and I had two cases that involved it. And it seems that left unbridled, lawyers with their fertile minds can always find a due process or equal protection argument for almost any issue that comes up before the courts. And to some extent, they have a certain amount of logic to them. If I were sitting back and trying to judge what kind of a government that I would like to have if I were that benign dictator, I think very often I could subscribe to that. But there's a certain amount of judicial humility that you have to have in recognizing that is not your right and that there are certain limitations that you have. But it almost is treated by some as an open-ended invitation to bring almost every complaint before the courts and make it a constitutional problem. I remember the first time that I sat on a case in which it was suggested that there was a constitutional problem because the principal directed certain people to have a shorter haircut. And there I was deciding this great constitutional question. I wondered if that's really what I had in mind when I became an Article III judge.
Well, it seems to me, I'm sorry, it seems to me that it's too easy to make it look like it's all the majestic generalities of the 14th Amendment. I think the most lively debate in recent years on the meaning of original intent has been conducted within the court, the Supreme Court, over the meaning of the religion clauses, right in the First Amendment. And in one rather famous case from Alabama, in which the Alabama legislature specified a moment of silence for prayer or meditation, specifically using the word prayer, the court divided over whether the Establishment Clause of the First Amendment, in that case it was being applied to the states through the 14th Amendment, but the real division was on the meaning of the Establishment Clause, whether the Establishment Clause should be construed to prevent the government from deliberately endorsing religion, or whether it should be read much more narrowly, simply to prevent the government from discriminating among religions or setting up an official state church. Now, Justice O'Connor, writing in concurrence with the majority, said that she thought that the Establishment Clause should be understood in terms of the general purpose of the framers, to avoid government endorsement of religion. Justice Rehnquist, dissenting, took the view that because the wall of separation was not directly in the mind of the framers, he points out Jefferson was in Paris at the time, that for that reason, it's wrong to read the Establishment Clause broadly. Now, it seems to me that even without getting to words like due process and equal protection, one has to choose between those two approaches. The fact, as Justice O'Connor pointed out, that there were virtually no public schools when the First Amendment was written, so that the issue of prayer in the public schools certainly didn't occur to the framers, might lead one, if one has a very narrow view of original intention, to say that official prayer in the public schools is just fine. If instead one says, the framers knew that the document would outlast the particular social conditions that gave it birth, and one has to look beneath the surface to what Justice Rehnquist in another case called the tacit postulates of the Constitution's provisions, then I think one would agree with Justice O'Connor. And I think the problem does not occur only in 14th Amendment jurisprudence. It occurs throughout the Constitution.
I think that's probably right, Professor Tribe. But it's really how you approach the problem, I think, will largely determine the outcome. For example, in the case from Nebraska where they had the paid minister giving prayer, Chief Justice Berger, in his opinion, went back through history and what was going on at the time of the writing of the Constitution, and based upon that history, made an application today. That is, he took the position, it seems to me in that case, that you do look at the framers' intent not only by what they did, but at the time of the adoption of the Constitution, but what was going on at that particular time. And certainly that case indicates that there was a more careful looking to what happened in the past, sort of the framers' intent, than there had been perhaps in other cases.
I was going to answer Professor Berns' question by saying that, at least from what I see both within my circuit and in the other circuits, that we probably get more litigation, and virtually all the criminal litigation deals with the Fourth Amendment rather than the 14th. And there the words unreasonable searches and seizures, warrant when a warrant is necessary and what are the particular places to be searched. And the courts have struggled with these phrases, and they aren't perhaps quite as majestic as some of the others.
Necessity, the courts will struggle with those
and the Congress has struggled with
that. No one argues about that.
No, and I'm saying that there's an interplay there.
If I could go back a moment, when Professor Berns spoke first of most of the difficulties in interpreting coming from the 14th Amendment, and then Professor Tribe, you said, well, that wasn't so, for instance, the First Amendment, and you, Judge Mikva, have spoken of the complications that come from the Fourth Amendment and unreasonable search and seizure, but still aren't they related to the 14th Amendment and that big change that occurred in the way the Constitution is read and the difficulties in interpreting it now, when the court decided that the 14th Amendment makes the First Amendment and the Fourth Amendment applicable to the states, whereas it's clearly written and was always understood to apply only to the federal government. And it's now the complication of having to interpret the meaning of the Establishment Clause, for instance, that there shall not be an establishment of religion. Now having to figure out what that means as applied to the states, whereas previously it was always understood to apply only to the federal government. Well, it seems to me that changes makes it much more difficult to interpret the Constitution.
I think it increases the volume of cases in which the issues will arise. But I really think that it is misleading to suppose that the problem is seriously accentuated in a qualitative way by the 14th Amendment. If I might just go back to, Judge Wallace, your example of the Nebraska chaplain case, a case in which the state legislature, using public funds, hires a chaplain to introduce the legislative session with a prayer. Now, in that case, Chief Justice Berger for the majority focuses, as you say, on the history. He says, at the time the First Amendment was written, prayers of this kind were common, and therefore it follows, perhaps not inexorably, but presumptively, that the Constitution doesn't condemn them. And I take it, Judge Wallace, that you are saying that that approach is congenial to you.
No, I was pointing out that that approach is one that the Supreme Court has taken.
From time to time. But if it took that approach very often, look what would happen. If it took that approach in the 14th Amendment, what would follow? It would follow that because segregated public schools were a common practice at the time the 14th Amendment was written and ratified and were not thought to be unconstitutional, that it was somehow too radical for the court in Brown v. Board of Education to have undone that.
You know, it's interesting, Professor Tribe, that every time I've been into one of these discussions where people adhere to the living Constitution theory, Brown versus Board of Education is the case that's always looked to, the example.
I didn't cite Brown versus Board. I
You
cited
will.
Baker versus Cotton.
You will.
You want to talk about Baker versus Cotton?
But when you think about it, though, for a moment, if you take a step back about the living Constitution idea, who's going to decide what the current living Constitution requires? That is, we aren't going to use the game plan that the founders had. We're going to say that's 2 centuries old. These folks were fine then, but there's a living Constitution. We have today's problems. We're going to now have this Constitution change. Who's going to make that decision? Well, the decision's going to be made by 9 people who sit in Washington, D.C., the Supreme Court. The assumption is, with a living Constitution, that this is beneficial for us, for the citizens, is that they'll make the right decision. That always when they make this Constitution alive to change, that the right decision will come out. Well, how can we guarantee that? It seems to me that if the founders took such careful pains to say the Constitution can only be amended by the constitutional process of amendment, that it's difficult for me to accept that sociological surveys now can amend the Constitution in its living part.
I guess what makes it, as I listen to you talk, I realize that you point out exactly how difficult these choices are, because we tend to try to resolve them by hurling slogans at each other. And I didn't hear Professor Tribe use the term living Constitution. I don't know whether he likes it or not. I don't particularly like it, because that does suggest, at least the connotations to me, suggest that it's no restraint at all. It just goes from judge to judge.
He reminded us that it has to be we have to remember that it's a living legal document.
Legal document, he said. A legal document is
different from a Constitution.
Is different from the notion that you can just pick and choose and say, I like this, I don't like that, therefore I'm going to go with this and not go with that, and here's a new one that nobody thought of, I'm going to put that in, which I get, which the connotations come to me from the words living Constitution. But the fact of the matter is that all of these represent very hard choices, and you suggest that we can somehow, that there's a judge machine, which you put in the facts and you put in the constitutional provision, and out comes a decision, and you know better than that. You know that these are struggles. I happen to agree both with Brown versus Board and the Chief Justice on the First Amendment case, the Chaplin case in South Dakota, and I think the reason, as I struggled through the prose of that opinion, they were long opinions as I recall, was that it wasn't that was only that was the history of the meaning of that clause, because there was a chaplain praying over the Congress that adopted that amendment. But the fact of the matter is that even today, you walk into the House of Representatives or the Senate of the United States, and there is a chaplain praying for the souls of those members, and those prayers are needed. And there's a chaplain, there's a paid marshal saying, God save the United States in this honorable court every day when we start to sit, when you start to sit. Let me just finish.
It seems to me that you exaggerate.
Can I just make the point?
Sure.
Then I'm sure you can find out where I exaggerated. The point I make is that what has changed about segregation of schools between 1865 and 1963, or whenever Brown versus Board, 54 was tremendous, and was a topographical change in our culture, in our institutions. What changed in voting habits between 1865 and 1960 was tremendous. There hasn't been that kind of sea change in the way we treat religion in our political institutions. I think both decisions are defensible.
Let me pose this question just by quoting one sentence from Justice Brennan. Judicial power resides, he says, in the power to give meaning to the Constitution. Now, another way of saying something like it would be judicial power resides in the power to ascertain the meaning of the Constitution. Is there a fundamental difference of approach in saying give meaning to the Constitution or in saying ascertain the meaning of the Constitution?
Is this from his Georgetown speech?
I think so, yes.
Well, see, another line
there's
he
the
had...
fundamental difference. I mean, the implication of the statement, of course, is that the Constitution means absolutely nothing until I, William J. Brennan, Jr., say what it means.
But the problem, Professor Berns, is that if you read the whole speech, that clearly is not the context in which that line was used. He went on to say, very clearly, he said, I realize that we are not final because we are infallible.
That's Jackson.
Well, he quoted Jackson, and he quoted it in a long paragraph in which he made it clear that he was aware that these are awesome decisions and that this is an anti-democratic or non-democratic institution that's making these decisions.
It seems to me that there is a difference between ascertaining meaning and pouring meaning in as though it were an empty vessel. I couldn't defend the latter, but I honestly don't believe that Justice Brennan or anyone on the court thinks he's engaged in the latter or genuinely is.
All right, well, then let me give you one other sentence from Justice Brennan, which is a little different. The ultimate question must be, what do the words of the text mean in our time? Now, that means you have to look at the words, right? But do you see a significant difference in that formulation?
Yeah, well, let me say something that I wanted to say a moment ago, and it's relevant here too. I want to say to Judge Mikva that I think he exaggerates the extent to which the Constitution was out of date. And Justice Brennan uses the phrase for a time that's dead and gone, I think, in that particular speech. Ab, in your initial presentation, you made some reference to the extent to which voting has changed and the Constitution had to be changed and so forth and so on. If I'm right in this, I think not a word in the Constitution had to be changed to allow women to vote, to allow black to vote, to allow women to hold office, to allow women to serve on your court, to allow women to serve on the Supreme Court of the United States, or as Vice President or President of the United States. Not a word had to be changed.
Well, that gets back to what you call constitutional and unconstitutional. Section 4 of Article 3 of Article 1 specifically says that times, places, and manners of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. Mm-hmm. And the legislature thereof in all those states had rules against non-property owners, non-women, age.
Right, exactly.
And the Constitution changed all that by saying no one shall be denied the right to vote. So technically you are correct. We didn't change the words of Section 4 of Article 1.
The point is important, though, Ab, because...
But we also didn't change the words of when we passed the 14th Amendment, we didn't change the words of the article which says that slaves would be sent back to their state from whence they came.
It didn't use the word slaves again. I could get off on that one. I'm simply making the point that the Constitution was not written as an 18th century document to survive for a few decades into the 19th.
We are in total agreement.
And it had to be changed very little to make it possible for us to live very happily and uniquely among all the countries of the world in the 20th century.
It is a tribute that we can agree upon that during these 200 years we have only 26 times had to go back and amend the Constitution. 10 of them were at the original founding of the Constitution.
Very few of those.
And two of them canceled each other.
Two of them canceled each other.
But I have to interrupt at this moment of strange, unique agreement between Professor Berns and Judge Mikva. We've explored, at least begun the exploration of this question, how to interpret the Constitution. And I think it's time for us to move on now to the question and answer session, because we have a knowledgeable audience eager to ask questions. May I have the first question, please?
I'm
Yes,
Fred
sir.
Quinn. I'm the International Coordinator for the Bicentennial of the Constitution with the U.S. Information Agency. And I'd like to ask our panelists what advice you have for Constitution writers in Africa, in Europe, in Latin America, and in Asia who are struggling with the questions of writing or revising constitutions.
Since I have no reason to go first except that I just made a speech on this to the proposed constitution writers in Brazil, I hope, and this is a hope that I'm not very confident will be fulfilled, I hope that they take the non-specificity of our Constitution as their model. I worry deeply that they are putting in everything, including the kitchen sink, and trying to guarantee all kinds of economic rights, the right to a job and the right to a home and the right to food. And while I'm all for those rights, they can't be guaranteed in many of those countries, and the Constitution is going to become a dead letter before the ink is even dry on the document. And I would wish they would incorporate some of those majestic generalities that we are arguing about, because they will have a document that will survive.
Sometimes easier said than done, though. When I helped the Marshall Islands write a constitution, I started exactly with Judge Mikva's preference. I wanted majestic generality, but they pointed out that they lived in far-flung islands, didn't trust each other to legislate often, wanted to pin it all down. So they ended up with an 85-page document, which guaranteed, among other things, protection against newsroom searches. Very detailed. I think we have to recognize when we help other countries write constitutions that we cannot necessarily export our capacity to be brief.
To that, I would...
Excuse me, go ahead, Walter.
I would add one other thing, Mr. Quinn. I was in Brazil last year, too, talking about the Constitution, and ran into the same thing that Judge Mikva was talking about, and offered the same sort of advice. I would add one other thing, however. I think it's important for these countries to realize that they cannot, in fact, are not likely, at least, to achieve constitutional government by relying on judicial review alone. That's an important thing. And I find a disposition among jurists from around the world to look to the Constitution of the United States and its happy bicentennial existence and attribute that to the fact that rights have been secured by the Supreme Court, when in fact, of course, the first time the Supreme Court enforced a First Amendment right against the Congress of the United States was in 1965, and the first time it enforced a religious provision against the Congress of the United States was in 1971. We tend to forget that sort of thing. We have, as Madison said in Federalist 51, we have civil and religious rights in this country, not for reasons with respect to the federal government. States, different proposition altogether. But with respect to the federal government, it has to do with the structure of that Constitution. We could not simply rely on judges. That, I think, is an important piece of advice to give to people around the world.
Mr. Quinn, I'd only add that in my experience in dealing with 13 countries in Asia, where I'm working with judiciaries there on behalf of the Asia Foundation, my experience has been that they have to learn more than just the words. Our document tells how we as a people are constituted, and it's survived because of something more than the document and the words. Other countries have tried copying identically what we've said and have failed. And if I have any message for those that are struggling with the Constitution, is to look at the basic freedoms and the basic thrust of what you're trying to accomplish for a people. That perhaps is more important than the words that are spelled out.
May I add one other thing, Mr. Quinn? And this, I think, has to be said in Brazil, too, Ab. We get smug about the brevity of the federal Constitution and its glittering generalities and so forth. We must always remember that when that Constitution was written, there were 13 states that had written constitutions that went into great detail with respect to a whole body of material that, well, under a federal system that was possible. And that is one reason why our Constitution was so brief.
As I understand these answers, we should advise other countries to have a federal constitution and a short one, and then they'll have all the troubles interpreting their constitution that we've been doing. Can we have this second question, please?
My name is Alfred Mullen. I'm an attorney with the Department of Justice.
Please, can you stand, please, for us?
Sorry. I'm an attorney with the Department of Justice, and I've had to endure Judge Mikva's questions many times, and the chance to return their favor, I think, may never occur again, and so I thought I would jump in. Judge Mikva, you and Professor Tribe have responded to these questions largely by referring to generalities in the Constitution and referring to those terms to the fact that they do need interpretation and construction. But that doesn't seem to me a full answer, because the generalities themselves do have limits. They do have fixed subject areas in which the Constitution intends to have the court work. And let me pose as the counter, say, to Brown versus Board of Education, another example, the abortion decisions. As far as I can see, there's not even a magnificent generality within which the court can pin its decision. The court talks about penumbras, about shadows, about privacy rights, although the word never does occur in the Constitution. And I wonder if that doesn't show a contempt for the majority of the court, at any rate, for any limitation whatsoever.
Well, if the question is directed to me, let me say that there are several phrases, to be specific, in the Constitution which talk about inferior courts. And I am a judge on one of those inferior courts. And whatever freedom all of you have to criticize the decision of the Supreme Court of the United States, specifically, as an inferior judge on a subordinate court, when the Supreme Court hands down a decision that covers the subject matter, it is the law of the land as far as I'm concerned, and I accept it and try to apply it in future cases. There are generalities involved, though, in the general abortion area. We are talking about this question of due process of law that came under the general doctrine of due process. I assume you are concerned about the fact, that part of your concern deals with the fact that the court particularly inscribed a right to privacy, and it is perfectly correct that the Constitution does not mention the right to privacy. Well, if I were one of the bosses instead of one of the inferiors, maybe I would use a different parsing out of that situation than was done in Roe versus Wade, and maybe I would have waited, because I believe a lot in the topography in which a Supreme Court decision comes down, and Justice Brennan talked about that when he talked about the legitimacy of the decision. Maybe it would have been better to have waited for the court to have stayed its hand. But again, that's a debate that the academicians here can argue about. Judge Wallace and I remember our position.
But is that your primary concern, that the timing was wrong? Or?
Well, no, primary concern, again, I don't want to parse out whatever disagreements I may have about the way that decision came down, but I think that a lot can be said about the legitimacy of a case in terms of its timing.
I don't think there's any quarrel about the timing. I think Professor Goldwin, when he asked that question, had in mind whether there might not be an additional reason, and perhaps even a more important reason, why, in our judgment, the court was wrong to do what it did or to decide at all Roe v. Wade. When the court does that sort of thing, in the first place, let me start with my conclusion. It gets into politics. But it creates a right, in this particular case, a right to privacy, which it then defines. To speak of a right is to describe an area exempt from political power. That's what a right means. The political processes may not govern, they may not enter. This is an area that is exempt from the politics. Now, before one does that sort of thing, especially before one talks about a fundamental right, one ought to be doggone certain that there's some agreement that it is a fundamental right. We, at the beginning of this country, instituted a government under the prescriptions of the Declaration of Independence in order to secure certain rights. We agreed about those rights. But if the Declaration of Independence had said, for example, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and sodomy, for example, I don't think we could have had a United States of America, because I don't think we could have constituted a government on the basis of those rights, whether the Supreme Court of the United States described it as a fundamental right or not. Now, that's the problem of this. Now, Mr. Tribe was counsel in that particular case, so he's going to have something to say about it, I'm sure.
Yes, I think you're right.
Don't feel that you have to.
No, but I wanted to anyway, but now you've given me all the more incentive. It seems to me that it misstates the question to ask whether the catalog of fundamental rights includes sodomy, abortion, and the like. I think the relevant right is the right to live under a system of limited government, in which, when government intrudes into the most personal spheres of life, a court will demand of the government a more particularized justification than some states have sometimes given. Now, that's a principle which I think is ingrained tacitly in the entire Constitution, and certainly in the Bill of Rights and in the Ninth Amendment. Without that principle, the court's decisions protecting people's rights to decide whether to have children, how to bring them up, decisions in the 1920s about the right to send your children to a private school, all of those decisions would be wiped away. It seems to me that what is excruciatingly difficult about the abortion case is not that the word liberty, which after all is in the 14th Amendment, is not capacious enough to encompass a woman's control over her own reproductive capacity. What makes the case excruciatingly and tragically difficult is the compelling character of the countervailing interest in protecting the life of the fetus.
Doesn't it make a strange situation, though, when Justice Douglas talked about these penumbra of rights, and you could see the shadow coming out, not knowing where it is, where it ends.
The shadow knows.
The shadow knows, and Cato. You're showing your age, by the way. But it seems to me that whether it's right or I agree with Ab, as an inferior court judge, you take what comes down to the Supreme Court. But I think it can at least be observed that the court, when it uses the penumbra approach of finding all of these rights which aren't spelled in but somehow just sort of emanate, that theory creates an ambiguity, and then after they've created the ambiguity, then they define the ambiguity and then develop rights out of the ambiguity. Now, whether it's right or wrong, I just suggest to you that that isn't really the same thing as finding a right that's spelled out.
No, but no, that problem. Gentlemen, I think we have to go on to the next question.
We're not finished with this one by any means.
We'll get back to it.
Jim Unger, the director of the National Forensics Institute here in Washington, D.C. At some risk, I'd like to return to what I think for this panel was the original document, and that was the title of the panel, How to Interpret the Constitution. My suspicion is that the original framers of that had special emphasis on the word how. And I was wondering if each member of the panel possibly succinctly could tell us what they saw as the legitimate resources, the legitimate areas one could turn to in interpreting the Constitution. Obviously, we have the text, but are there other sources as well that each member of the panel thinks are legitimate sources of constitutional interpretation in answering the question how to interpret the Constitution? What would those sources be?
Professor Berns?
Reference has been made to Baker v. Carr a couple of times. I'll refer to one of its progeny, Gray v. Sanders and then Reynolds v. Sims, where the statement was repeated. These cases have to do with legislative reapportionment, and Reynolds and Sims specifically has to do with the question of whether the rule of one man, one equally weighted vote applies to the second House of State legislatures. That's the question. How does one interpret the Constitution of the United States to answer that particular question? A question coming to the court in 1965, give or take a couple of years. Well, the Justice Douglas and Gray v. Sanders saw fit to refer to the course of American political thought, in a sense, extending from the Declaration of Independence through Lincoln's Gettysburg Address, and came to a certain conclusion, which I think that history does not sustain. Had he, for example, looked at the records, for example, the Federalist Papers about representation, the records of the Federal Convention on the question of representation, and the necessity to impose some Republican limits on the diseases of Republican government. Had he, for example, looked at Thomas Jefferson, after all, the principal author of the Declaration of Independence, had he looked at Jefferson's notes on the state of Virginia with respect to this question of representation, he would have found in query number 13, quote, "The purpose of establishing different houses of legislation is to introduce the influence of different interests or different principles." And I could go on. I would conclude that if one looks to the text, one looks to those documents that amplify the text, that indicate what the text might have meant to the men who wrote it, such as Jefferson's writings, Federalist Papers, and so forth, one can see that the court was simply wrong in Reynolds v. Sims. Simply wrong.
Well, let me respond as one of those that's been struggling for the last 16 years to talk about how we go about deciding these constitutional questions. In my judgment, every person should start with the text itself. I don't think that any judge could or would justifiably start without going to the text itself. The text itself does not cover every possible answer. There are some great overarching principles that are discussed within the Constitution. And so then a person has to look at the text, and to my judgment, those norms which are clearly expressed from the Constitution. Now this, I wouldn't go so far as, in my judgment, in the penumbra area, but then and again, there are some things that you can gain from the Constitution. For example, the structure of the Constitution sets up very clearly a way of protection. One is federalism. It divided the power between the states on one side and the federal government on the other, a separation of power. There was a second separation of powers within the federal government between the three branches. It seems to me that those structures tell you a lot about how you're going to approach a given interpretation of the Constitution. Those structures identify where the role of the court is and where the role of the Congress as the elected representatives of the people will be. Now, after you leave those, a lot of people believe, and I happen to be one of them, that you should look to the framers' intent. That can be secured through the debates and through the debates on adoption. And I don't think those are dead at all because they happen to be 200 years old. These are the people who looked at these basic principles and said, these principles will govern. And they didn't say these principles will govern with a sunset clause of 20 years. They said these principles will govern. They had in mind that those principles, as interpreted, would last through the history of the Republic. And my judgment is that that's fair. Now, when you get through that, you don't just plug in and automatically an answer comes out. Of course there's discretion that we apply. Of course there is. But there's a difference, I suggest to you, if you start with these basic norms of the Constitution to make that decision, than if you decide what's good for society today by your light of what you think society should be doing. That's my answer to your question.
I certainly agree with that, but look at the sentence. I think it's crucial. The framers decided these principles shall govern. It was principles. It was not laundry lists of examples. And then we debate what the underlying principles are. Do they include a general principle of limited government? Do they, and I believe they do. Do they include the general principles of checks and balances? And I believe they do. It seems to me that those principles are alive and well, but they're alive and well because we understand them at a level of generality that is as relevant today as it was earlier, precisely because we do not reduce them to a rather trivial set of frozen illustrations in history.
Do those principles, or does the principle of the separation of powers embodied in the Constitution include the principle that the two houses can be based on a separate, different principle of representation?
Certainly that the two houses of Congress can, but that was because of the great compromise that created the Senate.
So
it's not at all clear that a similar principle is applicable to state legislatures and local. That's where the debate is on Reynolds.
I will drop this subject by merely saying I see nothing in the Constitution of the United States that prohibits the states from following that particular sage advice of the founders with respect to the federal principle.
Do we have another question? Yes, please.
Louis Fisher, Library of Congress. On the question of how to interpret the Constitution, you spent, I think, all your time on how judges go about that task. You've talked, Professor Tribe, about method and technique difficulties. Judge Wallace talked about the anxiety of having 9 justices do this. But certainly it's true that Congress and the President have important roles, and I'm talking not just in the initial interpretation, which the Supreme Court would recognize, but aren't we talking about a much more dynamic process of a dialogue among all 3 branches, and the duty to interpret the Constitution is not just placed on the Supreme Court or on the judiciary. Do we have a much more vigorous dialogue among all 3 branches and also with the states?
I would respond to that
as
briefly as possible, Mr. Fisher. One of the things that disturbs me about what has happened in recent years, the increasing importance of the court and the court entering areas where, in my judgment, it ought not to enter and so forth. one of the consequences that, it seems to me, has been a tendency on the part of officials of other branches of the government to think that interpreting the Constitution is none of their business. The most egregious example of this was the second go-round of the so-called Equal Rights Amendment, when 65 senators sponsored the rebirth, the resurrection of that amendment, and its chief sponsor was the then Senator Paul Tsongas from the state of Massachusetts, who made the mistake of testifying before the Senate Judiciary Committee on that and was asked time and time again, what does this mean? And answered time and time again, he didn't know, it was up to the courts to say. Now, this is someone who's proposing to amend the Constitution of the United States. This is the chief sponsor of a proposed constitutional amendment who thinks it's his job not to know what the language means. Now, that's constitutional irresponsibility.
Well, I've seen plenty of examples of constitutional irresponsibility. I wouldn't have used that one because Senator Tsongas of Massachusetts, I think, was trying to say that, as with the Equal Protection Clause, when one recognizes a very broad principle, one is not going to know in advance in detail what all of its applications will be. But I do agree with the general thrust of Professor Berns' point, and that is, as Professor Fisher's question suggests, we ought not to treat constitutional interpretation as simply a puzzle about judicial review. The Constitution addresses all three branches of government, and we need a constitutional theory adequate to all three.
The fact of the matter is, you know, Mr. Fisher, the quickest way to empty out either chamber of the Congress is to get up and say, I'd like to discuss the constitutionality of this bill. And immediately everyone says, well, that's for the courts, and goes back to their office. I find that very distressing. As someone who believes in the primacy of the first branch, it dismayed me mightily then, and still dismays me, that my former colleagues just don't think it's part of their responsibility to worry about the constitutionality of an issue.
You know that,
Maybe a part of it is that there are less lawyers that get elected each year to the Congress than before. And for some reason, with the present company accepted, a lot of non-lawyers think it's not their responsibility to worry about the Constitution. Well, I happen to think it is.
Well, it's my responsibility to announce to us that this concludes another public policy forum presented by the American Enterprise Institute for Public Policy Research. On behalf of AEI, our thanks to our distinguished panelists, Professor Laurence Tribe, Judge Abner Mikva, Judge Clifford Wallace, and Professor Walter Berns.
It is the aim of AEI to clarify issues of the day by presenting many viewpoints, in the hope that by doing so, those who wish to learn about the decision-making process will benefit from such a free exchange of informed and enlightened opinion. This Public Policy Forum series is created and supplied to this station as a public service by the American Enterprise Institute, Washington, D.C. AEI is a nonprofit, nonpartisan, publicly supported research and education organization.